This channel examines the Jeffrey Epstein case using court documents, public records, and verified reporting. We do not speculate. We do not accuse. We document what exists, and what remains unanswered. Everything presented here is drawn from publicly available sources. This is not a theory channel. This is the file. For years, Epstein's flight records have circulated online. Screenshots, handwritten manifests, passenger lists shared as definitive proof. But here is the central question. Are we looking at a complete archive, or just a fragment? Most people assume that Epstein's flight logs represent every trip he ever took. They do not. What has been publicly released comes primarily from civil litigation disclosures. Pilot maintained handwritten manifests. Specific aircraft during specific time periods. That distinction is critical. Because a document introduced in court is not automatically a comprehensive aviation history. It is evidence relevant to a particular case. Nothing more. The source problem. The most widely circulated logs stem largely from the Boeing 727 used in the 1990s and early 2000s. Certain pilot notebooks. Documents unsealed through court proceedings. They do not necessarily include every aircraft Epstein owned or chartered, every international trip, every post-2008 flight, every internal aviation record. When the public treats partial records as total records, gaps become suspicious. But gaps may simply be structural. Multiple aircraft, multiple paper trails. Epstein used more than one jet over time. Different aircraft mean different tail numbers, different maintenance logs, different crew, different manifest formats. If records from one aircraft become public through litigation, that does not automatically expose records from another aircraft used in a different period. In aviation, documentation follows the plane, not the person. And when planes change, paper trails fragment. What missing really means. When people say records are missing, they often imply destruction. But missing can mean several different things. Not introduced in court, not requested in discovery, not retained by private operators, not digitized, not publicly unsealed. Private aviation documentation is not automatically stored in a central, publicly searchable database. Unless subpoenaed or required for regulatory review, some internal logs remain private. The absence of publication is not proof of deletion. It is proof of limited disclosure. The psychological effect. The belief that we have almost everything intensifies suspicion about what we do not see. But if what we have is only a slice, then the unknown becomes proportionally larger, not because it was erased, but because it was never public to begin with. Understanding that distinction reframes the conversation entirely. The real question may not be who erased the records, but rather, which records were ever public in the first place? To understand why some flight records appear missing, we must first understand how private aviation documentation functions. Because private jets do not operate like commercial airlines. There is no public booking system, no passenger ticket database, no searchable online archive. Private aviation runs on a different infrastructure. 1. FAA flight plans versus passenger manifests. In the United States, aircraft movements are regulated by the Federal Aviation Administration (FAA). But the FAA primarily tracks aircraft registration, flight plans when required, air traffic control communications, safety and maintenance compliance. The FAA does not maintain a centralized public database of passenger names for private flights. Passenger manifests in private aviation are typically maintained by the operator, logged by the crew, stored internally. Unless subpoenaed or entered into litigation, those manifests remain private business records. That means a flight can be fully legal, fully documented within regulatory systems, yet still not publicly accessible. 2. Part 91 versus charter operations. Most high net worth individuals operate aircraft under Part 91 of FAA regulations. Part 91 flights are non-commercial, do not sell tickets, have fewer disclosure requirements than commercial airlines. If Epstein flew under Part 91 ownership structures, passenger record retention would largely be internal. Charter flights under Part 135 involve stricter record-keeping, But even then, passenger lists are not automatically public. Regulated does not mean publicly transparent. 3. Tail numbers and ownership layers. Aircraft are identified by tail numbers, but ownership can be layered through shell corporations, leasing structures, trust arrangements. If an aircraft changes ownership or registration, documentation trails can shift between corporate entities. This creates fragmentation over time. It does not necessarily mean records vanished, it may mean they moved. 4. Retention policies. Unlike commercial airlines, which maintain extensive digital archives for operational and liability reasons, private operators may retain records based on internal policy, insurance requirements, regulatory minimums. Some documents are archived long-term. Others are not. Paper manifests from the 1990s, for example, may survive only if physically preserved. Digitization was not universal at the time. 5. What would be difficult to erase? It is important to separate two types of records. Hard to eliminate records. Air traffic control radar logs. Aircraft registration history. Maintenance compliance filings. Easier to limit records. Passenger name lists. Internal crew notes. Private scheduling documents. So when discussing missing flight records, we must ask, are we talking about aircraft movement or passenger identity documentation? Those are not the same category. 6. The transparency gap. Private aviation is legal and regulated, but it is not designed for public transparency. Therefore, when a high-profile case collides with a privacy-based system, the result is tension. The public expects total visibility. The system was never built to provide it. That gap fuels suspicion. Understanding this regulatory framework changes the framing of the question entirely. If some flight records are not public, it may reflect the structure of private aviation, not necessarily deliberate concealment. But that raises another issue. Were any records actually lost, destroyed, or withheld during litigation? When people say, flight records are missing, they often assume a dramatic scenario. Documents destroyed, evidence buried, names deliberately removed. But legal reality is more procedural and more complex. To determine whether records were actually withheld, we must look at what courts required to be produced in the first place. 1. Discovery is scope-based. In civil and criminal litigation, evidence disclosure follows a process called discovery. Discovery does not mean turn over everything that exists. It means turn over what is relevant to the claims in this case. That distinction matters. If a lawsuit focuses on specific victims during specific years, then document requests are often limited to certain timeframes, certain properties, certain aircraft, certain categories of communication. If a record falls outside that scope, it may never be requested, and therefore never produced. That absence is procedural, not necessarily suspicious. 2. The 2009 to 2015 civil litigation. Much of the publicly circulated flight log material became known through civil litigation, including cases brought by victims against Epstein and associated individuals. One of the most significant waves of unsealing occurred through litigation involving Ghislaine Maxwell. Court battles over sealed documents led to the gradual release of pilot logs, deposition transcripts, email excerpts, partial manifest entries. But these releases were incremental. They were not comprehensive archival dumps. Every unsealed document reflected what had been entered into evidence, not necessarily what existed in total. 3. Were there disputes over missing logs? In high-profile cases, disputes over document production are common. However, publicly available court records do not show definitive judicial findings that entire flight archives were intentionally destroyed as part of a proven cover-up. There were sealing disputes, redaction battles, motions to unseal names. But that is different from a court ruling stating, critical flight records were destroyed. That distinction is crucial. Public suspicion often exceeds documented judicial findings. 4. The difference between redacted and missing. Some logs were released with redactions. Redaction does not mean absence. It means information was present but legally concealed due to privacy rights, ongoing investigations, non-party protections. When redactions are later lifted, names appear, creating the impression that something was hidden. In reality, it may have been sealed pending court review. Legal opacity is not automatically evidentiary destruction. 5. The 2019 arrest and evidence seizure. When Epstein was arrested in 2019, federal authorities executed search warrants on multiple properties. Those searches focused primarily on digital devices, financial records, physical evidence. There is no publicly confirmed finding that federal investigators announced the disappearance of a master flight archive. That silence does not prove completeness. But it does suggest that flight logs were not the central evidentiary battlefield in the criminal prosecution. 6. The narrative gap. Here is where perception diverges from documentation. The public sees incomplete logs. The public assumes intentional removal. But court procedure operates on narrower grounds. If a document was never subpoenaed, never entered into evidence, and never required by the case's scope, it may simply remain private. That is not cinematic. But it is legally common. So the question becomes more refined. If missing records are not clearly proven to be destroyed in court findings, then what explains the fragmentation? Ownership changes? Aircraft sales? Corporate restructuring? Record retention policies? When analyzing missing flight records, one factor is often overlooked. Aircraft do not exist in static ownership. They are bought. They are sold. They are re-registered. They are transferred between corporate entities. And every transfer reshapes the paper trail. 1. Aircraft follow tail numbers, not people. In aviation, documentation is tied to the aircraft's tail number, not to the individual who uses it. When an aircraft changes ownership, registration details update. Corporate control shifts. Record custodians change. If Epstein used an aircraft under one corporate structure in 2001 and a different structure in 2006, the documentation trail would not necessarily sit in one continuous archive. It would sit where the plane legally resided at that time. The public, however, tends to think in personal continuity. If he flew, there must be one master log. Aviation does not work that way. 2. Corporate ownership layers. High net worth individuals often hold aircraft through limited liability companies (LLCs), aviation holding entities, leasing arrangements, trust structures. When ownership transfers between these entities, documentation can move with the operator. If the aircraft is sold, the new owner inherits certain records, but not necessarily internal passenger manifests from prior years unless contractually retained. This creates natural fragmentation. Not destruction. Just redistribution. 3. The sale of the Boeing 727. The Boeing 727 most associated with Epstein was eventually sold. Once sold, control passed to a new owner. Operational oversight shifted. Internal document storage may have transferred. Publicly available litigation records reflect certain periods of that aircraft's history, but not necessarily its full lifecycle documentation. Again, what is visible reflects what was introduced into court proceedings, not the entirety of what may have existed. 4. Paper era versus digital era. Many of the most discussed flight logs date back to the 1990s and early 2000s. At that time, digital record-keeping was not universally standardized. Pilot manifests were often handwritten. Long-term digital archiving was less common. Paper documents degrade. They are misplaced. They are archived in storage facilities. Unless litigation forces digitization, older private aviation records may remain analog. The expectation of a searchable, centralized database is a modern assumption imposed on a pre-digital system. 5. Corporate dissolution. If an LLC holding an aircraft dissolves, business records may be archived privately. They may be retained by accountants. They may be stored by former operators. There is no automatic public repository that captures those internal passenger lists indefinitely. Without subpoena, those documents can remain private indefinitely. Private does not equal erased. It equals inaccessible. 6. Structural gaps versus conspiratorial gaps. A structural gap occurs when aircraft ownership changes, entities dissolve, records remain internal. A conspiratorial gap implies deliberate deletion, coordinated destruction, intentional suppression. The former is common in private aviation. The latter requires proof. So far, publicly available judicial findings have not conclusively established a proven, court-validated destruction of a master flight archive. But structural fragmentation alone does not satisfy public suspicion. Because the public question remains: if nothing was intentionally erased, why does the timeline still feel incomplete? Sometimes a document exists, but you cannot see all of it. That distinction is at the heart of the missing records debate. Because in many instances, what appears absent may not be erased, it may be redacted. And redaction, legally speaking, is not deletion. It is concealment under court authority. 1. Why courts redact names? In civil litigation, especially cases involving sexual abuse allegations, courts frequently redact names of alleged victims, names of non-party individuals, personal identifying information, sensitive third-party data. The purpose is to balance transparency with privacy rights. If a person's name appears in a manifest but they are not accused of wrongdoing, courts may shield that name from public release. The document remains intact in the legal record. The public version appears incomplete. This creates a psychological gap. The page looks edited. The mind assumes removal. But legally, the information still exists within sealed filings. 2. Sealing orders and incremental unsealing. In litigation connected to Epstein and Ghislaine Maxwell, many documents were initially filed under seal. Years later, courts revisited those seals. Some names were unredacted. Others remained protected. Each wave of unsealing created headlines. New names revealed. But those names were not newly discovered. They were newly unsealed. That distinction matters. The perception of new discovery can amplify suspicion that something was hidden, when it may have been temporarily shielded pending judicial review. 3. Privacy versus public curiosity. Courts must consider reputational harm, ongoing investigations, rights of individuals not charged with crimes. The legal system does not operate to satisfy public curiosity. It operates to resolve disputes within defined procedural boundaries. When the public expects total transparency in a case involving elite figures, the inevitable redactions feel like concealment. But legally, redaction is often routine. 4. The media effect. When media outlets publish redacted pages, the black bars become visual symbols. They suggest secrecy. They imply suppressed truth. But black bars are not proof of destruction. They are proof of judicial limitation. And judicial limitation is common in high-profile litigation. A hidden name exists in a sealed filing. A non-existent record was never preserved or never produced. Conflating these categories intensifies suspicion. Understanding the difference refines the debate. Some flight entries may appear incomplete because names were shielded, pages were partially sealed, documents were produced in limited scope. Not because a master archive was erased. 6. Why the illusion persists. When people hear some flight records are missing, they imagine vanishing evidence. But in many instances, what is missing is not the flight, it is full public access. The tension between legal privacy and public demand fuels the narrative. And in a case defined by distrust of powerful institutions, that tension becomes magnified. So far, we have examined structural fragmentation, ownership transfers, regulatory limits, court disclosure scope, redactions. But there is another factor rarely discussed: human error. Not every gap requires a theory. Sometimes it requires a pen. Much of the most circulated Epstein flight documentation comes from handwritten pilot manifests. These were not designed for public scrutiny decades later. They were operational tools. Quick entries, abbreviations, initials, occasional misspellings. When those informal documents become global evidence, imperfections become magnified. 1. Handwritten logs are not court transcripts. Pilots often recorded passenger names manually before departure. These logs were created for weight and balance calculations, operational awareness, internal documentation. They were not sworn affidavits. They were not identity verification documents. If a name appears as J, Smith, Clinton, B. Clinton, or even a nickname, interpretation becomes subjective. Two different entries may refer to the same person, or two different people. The manifest alone does not resolve ambiguity. 2. Abbreviations and inconsistent formatting. Operational logs frequently use shorthand, initials instead of full names, surnames only, titles omitted, names written phonetically. If one flight lists Bill Clinton and another lists WJC, a reader unfamiliar with context may treat them as separate individuals. Fragmentation can emerge from formatting inconsistency alone, not from erasure. 3. Late additions and verbal confirmations. In private aviation, passenger lists can change shortly before departure. Last-minute additions may be verbally confirmed, written in margins, added with arrows or annotations. If a later copy of the manifest omits marginal notes, it may appear incomplete compared to an earlier version. That is an administrative issue, not necessarily evidence manipulation. 4. Paper storage and degradation. Many early logs were physical notebooks. Paper documents tear, fade, become partially illegible, lose pages over decades. Unless systematically archived, older manifests may survive only in partial condition. The expectation of pristine continuity may not align with real-world storage practices. When documents move through civil litigation, media publication, online reproduction, copies may vary. Redactions may differ between versions. Scans may cut off edges. Handwriting may be misread. What circulates online may not perfectly reflect the original artifact. Small discrepancies can snowball into claims of missing entries. 6. When imperfection meets suspicion. In an ordinary business context, minor record inconsistencies would be unremarkable. In a high-profile criminal case involving wealth and political connections, imperfection becomes suspicious. Human error becomes interpreted as strategy. But error and strategy are not interchangeable. To assert deliberate disappearance requires evidence of intent, not simply inconsistency. So far, we have examined structural, legal, regulatory, and human explanations for fragmented flight documentation. Yet one final dimension remains. What if some flights were never required to generate passenger manifests at all? There is a fundamental assumption behind the phrase, missing flight records, that every private flight must generate a formal, preserved passenger manifest. That assumption is not always correct. Private aviation operates under a regulatory structure that prioritizes safety and aircraft compliance, not public passenger transparency. And in certain circumstances, passenger documentation requirements are minimal. 1. Domestic private flights. For domestic flights within the United States under Part 91 operations, passenger manifests are not centrally filed with the FAA. There is no public passenger database. Identity verification standards differ from commercial airlines. A pilot may record names for operational purposes, but there is no federal rule requiring submission of a comprehensive passenger list to a public authority for each private domestic flight. This means, a flight can be fully legal, fully regulated, fully tracked in air traffic systems, yet generate no publicly retrievable passenger archive. 2. The difference between aircraft movement and passenger identity. Air traffic control radar tracks aircraft movement. It does not track passenger identity. So while aircraft position data may be recorded through ATC logs, transponder signals, flight tracking systems, those systems do not automatically preserve who was on board. This creates a structural separation. Movement records may exist. Passenger identity records may remain internal. If internal records were never digitized or preserved long-term, reconstruction becomes difficult, even without wrongdoing. 3. International flights and customs declarations. International flights require customs declarations. However, those records are handled by border authorities and are not automatically made public. Access may require government investigation, subpoena, formal legal process. Without such access, public visibility remains limited. Again, limited visibility does not equal absence of documentation. It equals restricted access. 4. Discretion as a feature of private aviation. One reason individuals use private jets is discretion. Not secrecy in a criminal sense, but privacy in a logistical sense. Private aviation was built to avoid public terminals, avoid ticket databases, avoid passenger publicity. It is designed to reduce exposure. When a case involving powerful individuals collides with a system designed for privacy, the result feels opaque, even if the system is functioning normally. 5. The expectation mismatch. The public often assumes private aviation should operate like commercial airlines. Full passenger lists, central databases, permanent digital archives. But private aviation was not built for public transparency. It was built for flexibility. That mismatch fuels confusion. If some passenger lists were never required to be filed externally, then their absence from public record may not require explanation beyond regulatory structure. 6. The critical distinction. There are 3 possible categories when discussing missing records. Never required to be publicly filed. Required but sealed or restricted. Required and intentionally destroyed. The third category demands proof. The first 2 are structurally common in private aviation. Understanding which category applies is essential before drawing conclusions. By now, we have examined structural fragmentation, legal redactions, human error, and regulatory limits. Yet one dimension remains: how media amplification transformed partial documentation into a perceived master archive, and why that perception persists. By the time Epstein's flight logs entered public discourse, a subtle transformation occurred. Partial records became perceived as total records. A handful of handwritten manifests, scattered court filings, and unsealed pages were reproduced online, shared on forums, and circulated through social media. The result? The public assumed, if it's not visible here, it must be missing. 1. Viral screenshots as evidence. Screenshots of flight logs, often cropped or redacted, became symbols of authority. Highlighted names gained disproportionate attention. Missing entries fueled speculation. Partial data was treated as a complete timeline. In reality, each shared screenshot represented only a snapshot of a far larger, and far less complete, archive. The viral spread of these images created the illusion of a master record, one that simply does not exist. 2. Repetition amplifies perception. Repetition reinforces belief. When multiple outlets repeatedly report, "Flight records show X attended Y flight," audiences begin to treat the statement as exhaustive. But repetition does not increase completeness. It increases familiarity. As familiarity grows, the absence of other records is assumed intentional, even if it is simply structural or procedural. 3. Black bars, redactions, and psychological impact. Redacted documents reproduced in media play a major role in shaping perception. Black bars suggest secrecy. Redacted names imply deliberate concealment. Public curiosity fills gaps with assumptions. Even when redactions are legally required and fully justified, their visual effect magnifies suspicion. The human mind interprets absence as disappearance, not redaction. 4. Misinterpreted partial logs. Many widely cited flight lists focus on a specific Boeing 727, selected years, certain court filings. These lists were never intended as comprehensive archives. Yet media framing often presented them as definitive. The combination of partial data, redactions, and high-profile names created a narrative that everything must be visible, and it's not. This is the illusion of completeness. 5. Public demand versus private reality. The public expects exhaustive transparency from high-profile cases. Private aviation, legal constraints, and procedural limits cannot satisfy that demand. The perception of missing records emerges at the intersection of human expectation, media amplification, fragmented documentation. It is amplified by the stakes, powerful people, global attention, and sensational headlines. 6. Preparing for conclusion. Regulatory limits, ownership changes, handwritten imperfections, redactions, media amplification. All contribute to the sense of incompleteness. Yet, none alone proves intentional erasure. 1. The convergence of factors. When multiple structural and procedural gaps intersect, The result is compelling. Partial records from one aircraft. Sealed filings in court. Handwritten entries with initials or abbreviations. Media screenshots highlighting high-profile passengers. The human mind, wired for pattern recognition, connects the dots, even when the dots themselves are incomplete. The perception becomes reality. Something must be missing. 2. Public suspicion and elite access. Flight logs involve powerful individuals. Every gap is magnified by context, wealth, influence, legal maneuvering. Even minor procedural omissions feel intentional. The combination of high stakes and incomplete visibility creates an environment where speculation thrives. 3. Fragmentation versus malfeasance. It is crucial to separate structural fragmentation from wrongdoing. Fragmentation, natural result of aviation rules, record-keeping, and litigation scope. Malfeasance, deliberate deletion or concealment with criminal intent. While the public often conflates the two, available evidence supports fragmentation as the dominant factor, though suspicion persists. 4. Why the narrative persists. Even decades later, Epstein's flight logs remain a focal point. Visual symbols of secrecy, redactions, blacked-out names. Partial lists circulating online. Recognition of high-profile names. These elements reinforce the idea that critical information is missing, even if no master archive ever existed. 5. Perception over proof. The enduring belief in missing flight records highlights a key truth. Human perception does not always align with procedural reality. Structural limitations, privacy laws, and operational practices create gaps. Public and media expectation fills those gaps with narrative. The result is a persistent story of absence, a story that may matter more culturally than it does legally. 6. Setting up the conclusion. Structural, regulatory, and procedural factors explain many gaps. Media and public expectations amplify those gaps into perceived mystery. Deliberate destruction remains unproven. After examining the structural, procedural, and perceptual factors, it's time to summarize the reality behind Epstein's flight records. 1. Records confirm movement, not intent. Flight logs document aircraft operations and, in some cases, passengers. They do not prove participation in criminal acts, knowledge of wrongdoing, personal intent. A name on a manifest confirms presence, not culpability. 2. Many gaps are structural. Fragmentation arises naturally from multiple aircraft and tail numbers, corporate ownership and shell companies, regulatory limits on required public disclosure, handwritten operational records, and human error. These gaps are not evidence of deliberate erasure, but of systemic structure. 3. Privacy and redaction. Courts frequently redact names for victim protection, non-party privacy, ongoing legal considerations. Redactions create the visual impression of missing data, but legally the records exist in sealed filings. 4. Media amplification. Partial logs reproduced online, combined with high-profile passengers and viral headlines, amplify the perception of completeness. The illusion of missing records often stems more from expectation than fact. 5. What the timeline truly shows. Epstein's flight records, when analyzed carefully, provide insight into his travel patterns, evidence of social access and mobility, partial visibility into who traveled on his aircraft. They do not provide a complete archive, nor do they serve as proof of criminal behavior for every passenger. 6. Lessons from the fragmentation. Understanding the flight records requires nuance. Structural gaps are normal in private aviation. Redactions and privacy law create apparent but not actual absence. Public expectation and media amplification distort perception. When taken together, these factors explain why missing flight records persist as a public narrative, even decades later. The story of Epstein's flight logs is not just about what exists, but about how human perception, legal procedure, and media attention shape understanding. Recognizing the difference between fragmentation, redaction, and intentional concealment is essential to separating myth from reality. The flight records illuminate patterns and networks, but they do not illuminate everything. And that is the ultimate lesson. Absence of evidence is not evidence of absence. The documents exist. The questions remain. This channel will continue examining what is public, and what is still hidden. If you value documented analysis over speculation, consider subscribing. More files coming.